The cap refers to the annual numerical limitations set by Congress on the number of workers authorized to be admitted on different types of visas or authorized to change status if already in the United States. Here we will talk about the caps as they apply to H visa category. The H1B visas, 65,000. U.S. businesses utilize the H1B program to employ foreign national workers in specialty occupations that require a body of theoretical knowledge and/or technical expertise in specialized fields. These include scientists, engineers, computer programmers. Congress has limited the number of new individuals that can enter the U.S. in the H1B category to 65,000 per year. This 65,000 includes the 6,800 H1B1 visas that have been carved out under the free trade agreements entered into with Chile and Singapore. While the H1B cap was reached within the first week of filing for several years, we have seen a reduction in the use of the H1Bs since the economic downturn. The cap is still reached, but not in the first few days of filing. That necessitated that USCIS set up a lottery system. Not all H1B petitions are covered under the H1B cap rules. Those not covered under the cap include current workers and certain aliens who will be employed in institutions of higher education or related or affiliated nonprofit entities, or at nonprofit research organizations or governmental research organizations. Petitions for current workers are petitions that are filed to extend the amount of time a current H1B worker may remain in the United States, to change the terms of employment for a current H1B worker, to allow current H1B workers to change employers, and to allow current H1B workers to work concurrently in a second H1B position. Let's look at cap-exempt petitions. In addition to the H1B cases noted above that are not covered under the Act, the H1B Visa Reform Act of 2004 established an exemption for the first 20,000 H1B petitions filed on behalf of aliens who have earned a master's or higher degree from a U.S. institution of higher education. Unfortunately, these, like the regular H1B petitions, are very quickly used up. Let's take a quick look at a case here. AB Corporation wants to bring 3 of their highly skilled computer analysts to U.S. to work on a new application of their proprietary software. Unfortunately, the decision was just made, so it appears that the H1B cap will be reached shortly. One of the workers still has a valid H1B from when he was sent to the U.S. a year and a half ago, and one still has an H1B visa that is valid from when he was U.S. setting up the parameters for this project. That only leaves one worker that needs a visa. He had an H1B visa, but has been back in India for over 2 years. Is he subject to the cap, or can he get a new visa for him without having to worry about that? Since he's been outside the U.S. for over a year and does not currently have a valid H1B visa, he will be subject to the cap. You will have to get the petition ready quickly, get it filed, and get it in under the cap for him. If you can't complete it in time, you will have to look at other options for him, possibly qualifying him as a specialized knowledge intercompany transferee. H1B1 Visa. This has the 6,800 visas. Of the 65,000 new H1B visas available, 6,800 visas are set aside during the fiscal year for the H1B1 program under the terms of the legislation implementing the U.S., Chile, and U.S.-Singapore free trade agreements. An H1B1 is a national of Chile or Singapore coming to the United States to work temporarily in a specialty occupation. The beneficiary must have a bachelor's degree related to the job offer. Unused visa numbers in this pool can be made available for regular H1B use with the start dates beginning on October 1st for the following fiscal year. For instance, USCIS added 5,800, the projected number of unused fiscal year 2007 H1B1 visas for Chile and Singapore, to the fiscal year 2008 H1B cap. Let's turn now to the H2B Visa. The H2B Visa category allows U.S. employers in industries with peak load, seasonal, or intermittent needs and one-time needs to augment their existing labor force with temporary workers. This is for 66,000 visas. Typically, H2B workers fill labor needs in occupational areas such as construction, healthcare, landscaping, timber, manufacturing, food service and processing, and the resort and hospitality services. The H1B numerical limit set by Congress per fiscal year is 66,000, with 33,000 allocated in the first half of the fiscal year and 33,000 allocated to the second half of the year. For several years, the Save Our Small and Seasonal Business Act of 2005 allowed the USCIS to not count returning workers against the cap. Unfortunately, the returning worker provisions expired at the end of fiscal year 2007, September 30th, 2007. H3 visas. The H3 non-immigrant visa category is for aliens who are coming temporarily to the U.S. to receive training other than for graduate medical education or training. The training may be provided by a business entity, academic, or vocational institute. While the H3 visa category itself does not have any numerical limits, there is a limit of 50 visas per year allocated to H3 aliens participating in special education training programs. Relief on the horizon for the H visa cap. With this being a midterm election year, the economy is still in recovery mode, and with immigration reform being such a hot-button topic, it is unlikely that we will see any meaningful legislation addressing the H1B cap. Numerous bills have been introduced in the past several years, none of which have made it very far in the legislative process. These have included the Skill Act, SKIL, and the High-Tech Worker Relief Act. Both bills were aimed at reforming U.S. visa programs for highly skilled foreign workers or providing temporary relief from the H1B cap, and both failed to get out of committee. There is still much talk floating around Washington, D.C. about comprehensive immigration reform, but with the legislative session winding down and the fight Congress has had this year on health care reform, nobody seems to be in the mood to bring a new bill to the table. We will have to wait and see where things go. Concluding now, with the H visa caps playing such a large role in being able to bring employees to the U.S., it is wise for employers to start planning early and to consider other visa categories, including the L1, J1, E2, and O1 visas. Look at our success stories at www.visapro.com to learn how VisaPro helped clients develop their visa strategy so they don't have to rely on the H1B visa at all, and how some are still able to bring all the personnel to the U.S. as they need. Our attorneys have the experience to review your particular facts and assist you in developing alternatives to the H1B. Contact VisaPro if you have any questions regarding work visas. Our experienced attorneys will be happy to assist you. We cover the latest immigration happenings on employment visas in Immigration Monitor, our monthly newsletter. Again, go to our website at visapro.com to subscribe to Immigration Monitor.